Veterans Claims is now in session. The Honorable Mary J. Sholin presiding. All who have business before this court draw near and you shall be heard. God bless the United States and this honorable court. Please be seated.
Good morning. My name is Judge Sholin. To my right is Judge Peach. To my left is Judge Allen. We're here today to hear the case of Vicki M. Quinn versus Robert L. Wilkie, Secretary of Veterans Affairs, docket number 17-4555. Would counsel for each party please note your appearance for the record?
Please the court, Kenneth Carpenter, and Pearl Francis Jackson.
Thank you.
Judge Sholin, may it please the court, Drew Silo on behalf of the Secretary of Veterans Affairs, and with me at counsel table is Richard Daly.
Thank you. Does appellant's counsel wish to reserve any time for rebuttal? Thank you. Begin when ready.
May it please the court, Kenneth Carpenter appearing on behalf of Ms. Quinn. The Federal Circuit in the Cook case interpreted the phrase that is at issue in this appeal. That phrase is decides any appeal, as used in 38 U.S.C. 7107B. They interpreted it to mean that the board was required to provide a veteran a hearing before it decides an appeal. This court's disposition of this case, Ms. Quinn believes, is controlled by the decision in Cook. The interpretation includes a hearing before it decides an appeal following remand from the board, just as it included following remand from this court. There is no basis in fact or in law to distinguish or otherwise limit the right of an appellant to a hearing before the board under 7107B. In arriving at its interpretation, the Federal Circuit relied upon the traditional rules of statutory interpretation, specifically in addressing the phrase at issue, decides any appeal.
Mr. Carpenter, can I interject, please?
Yes, please.
Did your colleague raise the failure of the board to grant a hearing when the case was before the board? Did they present any sort of briefing or argument?
We believe that he did, Your Honor, but honestly, I don't recall looking closely as to whether or not it was there was clearly a request made.
But if there's no argument below and the board may or may not have made any comment on it, should we entertain your argument at this point?
Well, I think so, Your Honor, because it's a question of whether or not the rights under the statute were afforded by the board. The board is barred from proceeding to decide an appeal by the interpretation of 7107B by the Federal Circuit's decision in Cook.
Right, but the Federal Circuit has also held that the absence of raising certain arguments before the board has been construed to be a waiver. Can you explain why we shouldn't take that in this case?
Well, Your Honor, because the proceedings before the agency are intended to be non-adversarial. And it would seem to me totally inconsistent that a party would have to raise the issue of entitlement beyond making a request for a hearing that was denied.
Okay, please proceed.
So it just seems to me that the issue is joined properly and before this court on the basis of the failure to afford a hearing. And that really goes back to the question of what does the phrase decides any appeal mean.
Could I ask you, you were, before Judge Sholin asked you about the waiver argument, you were talking about the Federal Circuit.
Yes.
So one part about the Federal Circuit's decision in Cook that is confusing to me is whether or not that court treated the statute as ambiguous and therefore interpreted it or considered it unambiguous. Do you have a view on what they did and whether it matters?
I do, Your Honor. And I do not believe that they reached the issue of ambiguity, that in the words of the Federal Circuit, they used the traditional rules of statutory construction to look at the plain language and determine whether or not that plain language did or did not convey the intent of Congress. And they concluded clearly that it did convey the intent of Congress, and that that intent was to provide a hearing before any appeal was decided, and that the term any was an expansive term as had been interpreted by the Supreme Court, and further that when connected or coupled with the singular pronoun appeal, the Federal Circuit concluded that that meant that the group, which in this case is the appellants, were entitled before there was a decision to be afforded a hearing if they desired one. Mrs. Quinn expressed that desire. Mrs. Quinn did not get a hearing. Therefore, the statute was violated. What the Federal Circuit did was to make a determination by looking, as courts are required to do in questions of statutory interpretation, to the words, the language used by Congress. They didn't make a express determination that the words were clear on their face, but looked using the tools of statutory construction to determine whether or not the meaning could be ascertained. And I think that that is entirely appropriate, if you will, at step one of Chevron for every reviewing court to do when they're looking at the meaning of a statute, and not simply to jump to the question of whether or not the term or phrase is ambiguous.
So are you familiar with 38 CFR 20.1507?
It doesn't ring a bell. If you could just elaborate for, maybe it'll.
So, well, it is a rule. It's labeled Rule 1507 hearings.
Ah, yes.
Right.
Okay.
And subsection B1. The subsection B is talking about hearings before the board, and subsection 1 of B says only one hearing before the board will be conducted.
Right.
So my first question about this is, do you have a position about the relevance, if any, of this particular provision of the CFR to this appeal?
That any validity that that provision had has to give way to the Federal Circuit's interpretation under Cook, and that any time a regulation is in contradiction to a statute, the regulation has to give way.
And so one of the oddities, potential oddities, although I think I have an explanation for it, is that although this statute, this regulation, 1507, was cited by, I think it was the RO in this case, in a letter saying we're not going to schedule another hearing, it wasn't relied on, I don't think it was cited at all by the board here, nor was it discussed in Cook.
No.
Do you have an understanding of why that would be the case, that this would not have been referred to?
Well, I think.
I mean, I'm asking because it seems like this would be a relevant source of law, right? There's a CFR provision that says you only get one hearing, and that might be not valid, right? It might be inefficient, or incorrect. But that's why I asked you about what you understood the Federal Circuit did in terms of the language, right? Because had it found it ambiguous, one would have thought it would have talked about a regulation that would be applicable. And maybe this isn't, but it does say only one hearing.
Well, it seems to me, Your Honor, that the appeal that was taken by the government of this court's interpretation of the statute, which was changed by the Federal Circuit, the government's position in their appeal was that the verbiage of that regulation was the correct interpretation. I think correctly, they didn't rely upon the regulation because until there was a determination that the statutory language was ambiguous, then there wouldn't be any leverage for the government to assert the interpretation that is found in that regulation. So it just seems to me that although there is some anomaly, the anomaly exists because the question of ambiguity did not arise. So we didn't get to step 2 of Chevron, which means there was no reason for the Federal Circuit to look to whether or not there should be any deference given to an interpretation that may have existed in a regulation.
Go ahead.
Counsel, I'd like to bring to your attention, I'm going to read a sentence from the Circuit Court's decision in Cook, then I'm going to ask a question on that.
Certainly.
Okay. It says here, we agree with Cook that Section 7107B entitles him to an opportunity for an additional board hearing in these circumstances. So what is your understanding of the term "in these circumstances"? Now, this is Cook at the Federal Circuit.
Yes, and I'm aware of that portion of Cook. I think you have to look at the totality of the opinion in Cook when trying to understand these circumstances. As I read Cook, these circumstances refer only to the circumstances presented by this appeal. In other words, the question in the appeal was, did this court correctly interpret 7107B when it said that there was an entitlement to a hearing following a remand from this court? However, I believe that the Federal Circuit went further when it said that when an appeal is again reviewed and decided by the board on remand, a claimant is entitled to an additional opportunity for a hearing. And that language was not qualified.
Do you see your client in the same circumstances as Cook in the Federal Circuit?
To the extent that both Mr. Cook and Mrs. Quinn were denied a hearing, yes. The difference is that I think there is even more vitality or justification, if you will, for the adoption of the interpretation made in Cook to the circumstances presented in this case, because it is a request for hearing before the agency. And because it is, we are in a non-adversarial role as opposed to the effect of an adversarial proceeding on the non-adversarial.
Do you think that this would make a difference, that in Cook, the appellant never got a board hearing on the merits?
That would be correct, but Mrs. Quinn never got a hearing on the merits. The hearing on the merits resulted in a remand to the agency for development of further evidence. So while she got a hearing, she didn't get a decision on the merits. She got a decision in which the board found that the record was inadequately developed and that it needed to go back to the agency of original jurisdiction for additional development, which is compelling, similar to the circumstances in Cook, because now we have a different record. But even if you didn't have a different record, the government makes reference to a mere ministerial review, such as, I presume, VCA notice, where the record itself does not necessarily change. The salient question is whether or not there is a dispositive decision. And a remand, as this court has held, is a non-final decision. So there was no final disposition by the board of Mrs. Quinn's appeal when she took the appeal to the board for the first time, and she had her hearing. When it came back after additional evidence was developed, she requested another hearing and was denied the opportunity for that hearing.
I'd like to probe sort of the boundaries of your statement there. So you're asserting any time that there's a non-final board decision, somebody would be entitled to a subsequent hearing?
I am.
So let's say there's a board decision that denies benefits, somebody appeals to the court vacates the decision, I guess now vitiating the finality. During that 90-day window where you can submit additional evidence or argument, somebody requests a hearing. Would the board now have to provide a hearing?
Yes.
Even if they'd already given one on the way up and there's no new evidence?
Yes.
So there's the evidentiary basis being different isn't a issue that decides whether you get a hearing or not.
As I read the Federal Circuit's decision in Cook, they interpreted the phrase as being both expansive and not imposing limits. To impose a limit based upon something that doesn't exist in the statute, i.e. that there was no new evidence, is to embroider, to add on to the statute language that simply isn't there, and more importantly, to create a limitation.
So basically, anytime a veteran is willing to wait for a hearing, their case comes back to the board, they're entitled to a hearing under your scheme.
Under my reading of Cook. I will blame it on the Federal Circuit. You can blame my argument on me.
Okay, thank you.
I think and just to follow that question, Your Honor, I believe that it is important to understand that Cook really talks in terms of there being no limitation and no distinction that is created under the statute. And if there is no distinction and no limitation, then that clearly must extend to the facts as presented in Cook.
I actually can talk about a potential limitation that Cook raised, that in their definition of appeal, they talked about reviewing a lower body decision by the higher body.
Correct.
So if in my circumstance, when it's on its way back down from the court, would that still fit that review?
Well, I believe it would, Your Honor, because there is no longer a final decision by the board. A new board decision is mandated by this court. The language is before any appeal is decided. And if the language is before it is decided, then the predicate is an entitlement to be afforded the opportunity for a hearing. And Your Honor is correct. It is an opportunity for a hearing. It's not a mandatory hearing. They don't have to give a hearing unless there is a request for a hearing. And the request for the hearing, once made, should be honored, as I believe the Federal Circuit interpreted the language of 7107B.
In your last 2.5 minutes here or so, could you touch on what I consider the last part of this? So there's the waiver question, there's what does the statute actually mean question, and the third part for me is harmless error if the statute means what you say. Are you with me?
No, I think I lost you at the turn, Your Honor. I'm sorry.
That's all right. I'm a crafty little beast up here. So what I mean is the way I see the issues here is the first one is the issue that Judge Schoen started out with, which is did you waive the argument below? Assuming you didn't, what does the statute mean?
Correct.
If it doesn't mean what you say, then we're done. We pack up our books. If it does mean what you say, then in my little world, the third piece is, was this error harmful?
Right.
And so I just wanted to have you have an opportunity to explain to me why that is.
I see. And now I'm with you. To me, this error cannot be even asserted to be harmless because it is a substantive right. And the substantive right is created by Congress. It is mandated by statute that a hearing be afforded before an appeal is decided.
So, but it can't. So it can't be just because something is a substantive right that its deprivation can't be harmless, right? Because you can have harmless error in a constitutional right, correct?
assuming for the purpose of this argument that that would be correct, I do not believe that that is possible in this system. This system is predicated upon an administrative, adjudicatory, and appellate proceeding that is intended by Congress, without qualification, to be non-adversarial. When you impose, as the regulation that you cited to imposes, a limitation on a right that is afforded by statute to have a hearing before the appeal is decided, and that hearing is not afforded, that is prejudicial. There was a statutory right to the hearing, and the right to hearing was denied.
And so Nova submitted an amicus brief in this case.
Yes, it is.
In which everybody seems to agree that our court's decision in Cook, its reasoning in Cook, is sort of taken over by the Federal Circuit's reasoning. Except Nova said, we think that the harmless error portion of this court's decision in Cook approached the issue the right way, and the Federal Circuit didn't touch that. Do you agree with that position? And if not, do you have anything else about that?
Well, I don't disagree with it, but it would not be the way that I would present, on behalf of Mrs. Quinn, the question of whether or not this was or could have possibly been a harmless error.
So basically, your position is, I'm going to characterize it, your position is, and I don't mean this term pejoratively, a little bit more extreme.
Yes.
Right. And the position that amicus advances here, which is based on our Cook decision, is, hey, these things could be harmless, but this type of thing isn't because X, Y, and Z.
Yes.
Okay.
Yes. And I think that is a fair and accurate characterization of Mrs. Quinn's position. And again, it's because of where this error happens. It happens as a precedent, if you will, to the decision. And that Mrs. Quinn's position is that Cook could not have been more clear that you cannot have a decision without affording the opportunity to a hearing to a veteran.
But the clarity of a right, such as the right to an exam or right to whatever, I don't think that necessarily leads to the waiving of a requirement to establish prejudice. It has to be something different than the clarity with which the violation happened or the clarity with which the Federal Circuit spoke of that this is a substantive right or a right that the veteran has. Veterans have many rights, but we still consider prejudice. Dawn, could you please add 2 more minutes?
I believe I understand what you're saying, Your Honor, but the distinction that I would draw is that when a statute mandates that a hearing be afforded.
Is it your distinction based upon the nature of the right?
Yes.
In that it's notice and comment, or ability to be heard?
Notice and opportunity to be heard to participate. That's correct.
Okay, thank you.
And to me, that's where the prejudice arises. Getting the right to an exam, there is not necessarily a notice and opportunity issue, except obviously as to maybe access to the examination report, et cetera, but not as to the right to the examination. So unless there are further questions.
Thank you.
Thank you very much, Your Honor.
Judge Cholin, and may it please the Court. The Court should affirm the Board's July 2017 decision because the appellant received an opportunity to and did testify prior to the only decision on the merits in this case. And the facts in this case are distinguishable from Cook, where the Court vacated a prior final Board decision and remanded for a new Board decision such as the opportunity to be heard again prior to any new decision was necessary.
So you inserted a word or two words, I'm having trouble counting apparently, right? You said a decision on the merits.
Yes,
right? But that's not what 7107B says, right? It just says any decision.
That's correct, Your Honor, but the Secretary would assert that 7107B must be read in context of Chapter 71 as a whole. Under Chapter 71, a few statutes earlier, Congress specifically defined what a board decision was in 7104, and in particular, there were two requirements that bear on this case. The first is under 7104A, which requires that it be on an entire record, that the board consider the entire record, but more importantly, under 7104D, that the board make a decision on the relief sought, either granting or denying the benefits.
But does this make sort of a common sense point here, right? So you could imagine an adjudicatory system in which Congress says you don't have in-person hearings, and subject to the due process clause and what constraints that might have, that would be fine. And you could also imagine a system in which Congress said, you can get a hearing every Monday as long as your claim is pending. You can get them over and over again. Inefficient, but maybe Congress decides that's okay. So here Congress uses the term any decision, which means, it seems to me, Congress wasn't just trying to be flippant, as my every Monday comment was. It was trying to do something. And it seems logical to me. It was trying to give a claimant the ability to argue or be present to argue and present testimony on a given record. That makes sense to me. It seems to me that if the board does what it did here, not in the decision under review, but the initial one, right? So you have a hearing, and then the board says, this record is not good enough. It needs more evidence. And I understand your point is that's not a decision. Okay. Then it goes back to the RO, and we get a whole bunch of new evidence, let's say, and now it comes back before the board. It just seems counterintuitive that we'd read the statute to say, well, in that situation, the veteran doesn't get a chance to say anything else because he said something before. But of course, what he said before was on a record that the board said isn't good enough for me to decide. So he gets to testify when the record isn't good enough, but when the record is good enough for the board to make a decision, he doesn't get a hearing. That just doesn't seem like a rational way to read the statute.
Your Honor, the Secretary would assert that appellant is not without redress. So in this circumstance where a medical evidence is developed, which is, well, I'll get to that point, sorry. Where medical evidence is developed, appellant, even if they don't have the opportunity to testify again, there are multiple procedural safeguards built into Title 38 that allow each claimant to respond in writing, present argument, present evidence.
Well, absolutely, and I'm not contesting that there are other things that can be done, but looking at just this right that Congress gave, right? So Congress gave a right to have a hearing before the board decides any appeal, right? And I understand your position. The first board decision, the one that said the record wasn't good enough, wasn't a, quote, decision. Yes. Only the second one was, because it reached a merits determination. And I understand that's your position, right? But what I'm saying is, I'd like your response to the fact that the Secretary's reading of that provision means the veteran gets a hearing when the record is incomplete, but does not get a hearing at the time that it is complete. And the fact that there might be other ways to submit evidence doesn't actually go to why that anomaly that I'm suggesting here would be consistent with what Congress wanted. Do you see what I'm trying? I'm trying to get the position about why that isn't sort of an absurd way to think about it. And by the way, I should say absurd, not in like the street way, like the legal way.
Yeah, absolutely. I understand your point. So in Cook 1, this court talked about the history of 7107B and talked about the importance of hearings generally when they spoke about the opportunity to be heard, to make a credibility determination, to develop the record, to make sure that the record is complete, and to make determinations as to where the record could be developed. In that scenario, appellant has had the opportunity to testify, to address what's important for the board member has had the opportunity to make a credibility determination and then based upon that discussion potentially develop the record more. But that doesn't change the fact that Congress specifically made it, as the Federal Circuit discussed, the right to a hearing prior to any decision. And that decision and deciding in the context of 7107B, the Secretary would assert that rules of statutory interpretation require that you look at least within the statutory scheme, but also in the context of that same chapter, how they defined a decision. And it's very clear that that was based on the underlying portion, and Congress is aware and built in the procedural safeguards that allow later participation, even absent the opportunity for a hearing. Also, Your Honor, it bears noting that under 20.1304, request for a decision after a Form 9 is filed must be provided with good cause.
The request for a decision?
I'm sorry, I misspoke. For a hearing. So the request for a hearing after the Form 9 has been filed, there's a requirement that the claimant provide good cause. And it also talks about delay in requesting that hearing. So that also assumes that there wasn't one previously requested. Here there was a hearing that was previously requested. The Form 9 was filed. The board decided that it needed more evidence and remanded for that evidence, and subsequently the appellant requested a second board hearing.
I'm sorry, I'm going to interject. I don't know that your reasoning is persuasive to me when you line it up with the facts of Cook. Because if your statement that you get one before a decision is made, in Cook, the Federal Circuit told him he gets to have two. So how does that work with your analysis?
I apologize, Judge Cholon, if I wasn't clear. So in Cook, the important part was that there was a decision which was vacated and a new decision was necessary. So the claimant and appellant in Cook was entitled to a board hearing prior to each of those decisions. And once a new decision was necessary and the words any decision required that a new opportunity for a board hearing be provided.
So the vacating of the board decision by our court through the JMR, I understand that vitiates, that doesn't just vitiate the finality of it, voids it altogether.
Yes, Your Honor.
But nonetheless, he still had a hearing, Mr. Cook did, in the first instance. So if that decision doesn't exist anymore, how is he now getting a second hearing before one decision?
Because it's
The Federal Circuit told you to.
Yeah, pretty much. There's a legal, I guess the way that it's looked at is even though in the context of the claim that doesn't exist, there still was a board decision at one time prior to which he had a board hearing. Insofar as that one went away and it's coming back from a higher court with instructions to provide a new decision, the opportunity for a new hearing is required under the language any decision under 7107B, Your Honor.
Does the logic of limiting it to that circumstance work with the questions that Judge Allen was asking you about this person hasn't had an opportunity to speak to, like Ms. Quinn, to a more complete record, yet Mr. Cook gets this opportunity because the board finally made a decision that he could appeal to the court and then get it vacated. How is that fair?
Your Honor, what the Secretary is asserting is that the appellant in this case received the process, the opportunity to testify that she was entitled to. And in Cook, Mr. Cook received an opportunity to testify, after which he received another opportunity just based upon the fact that the prior decision was vacated. In any appeal, if there are more than one decision, then the Federal Circuit's reasoning requires that there be a second board hearing. But where there's only one final decision, there's only the requirement for one board hearing.
But to to follow on to Judge Schoen's question, I asked you the one question about the policy with the different record. Imagine this. So based on Cook 2 from the Federal Circuit, unless something is deemed ministerial, if this court vacates and remands, the person gets the right to a new hearing. Do you agree with that? I mean, not you might think it's wrong, but much like us, that's what the Federal Circuit said, and we follow it, right?
Yes, Your Honor.
Okay. Assume that a remand then from our court is something that is not atypical, and the reason for the remand is reasons and basis. Okay, you just didn't explain yourself well enough. Now we all know that lots of things happen when we do a reasons and basis remand that doesn't have anything to do with the reasons and basis, right? But let's just assume that what actually happens is the board only responds to what we said. You did not explain yourself well enough. So in theory, the board is going to have exactly the same record, and all it's going to do is have the VLJ sit down and write a more detailed decision. In that context, the person gets a second hearing. But in this case, where the record is dramatically different from the first hearing, they don't. And again, I'm just saying that seems like such an odd thing. And I want to get the Secretary's reaction to that.
So the reason in Cook that it would be required under the circumstances you present where it's a reasons or basis remand is because Cook interpreted 7107B to require prior to any decision a board hearing. And insofar as that was their interpretation and a new final board decision is necessary, they would get that even if they didn't want the opportunity to. And that would be up to that individual claimant to decide whether it was something that would benefit them. But here, Your Honor, where there was only one prior final board decision and the Federal Circuit specifically interpreted that's how they read 7107B, it wouldn't be necessary, even though further evidence was developed.
No, I understand descriptively your position, right? You're making that very clear.
Yes.
What I'm trying to do is you're advancing an interpretation of decide any appeal that by the words you're inserting, and I'm not suggesting you're reading it wrong, right? You're saying decide any appeal on the merits, right? Or you've said final decision, right? What I'm trying to do is, since we have to interpret those words, we need to interpret the words in a way that doesn't lead to bizarre results. So we have a fixed point, which is what the Federal Circuit said, right? So the words mean what they said there. So it would mean that even if it's going to be an exact redo of what happened the first time, they get a second hearing. And my point is, should we interpret the words in the context of this case in a way that then would say, even with an entirely different factual record, you wouldn't get a hearing, right? And so I'm trying to figure out what you think about the fact of, does that seem like a bizarre result? Because if it does, we're supposed to interpret statutes to avoid that.
I don't believe it would be a bizarre result, Your Honor. And I think that overall in the statutory context, where it's an ex parte system where we're developing evidence at every step of the way and where the duty to assist requires the board to assess whether or not it has a final record and go back and maybe multiple times remand, that it's reasonable that there wouldn't be a board hearing at every single time evidence is developed. Rather, what's built into the system is the opportunity to participate by submitting, as I said before, argument, evidence, participating in that way and having the opportunity to be notified as development of evidence through SSOCs, which thereafter they have a certain amount of time to respond to. And it also, the Secretary would point that even though there may be a benefit flowing from the opportunity to be heard every time a claimant requests or every time the board develops evidence, there's also the other side of that, which is that the VA is working, it's an already overburdened system with a finite amount of resources, so it has to comply with the duty to assist, but it can't provide an opportunity for a board hearing every single time there's a remand. As to that, as of January 2019, there were close to 70,000 veterans waiting for board hearings, with close to 589 days that they were waiting for each board hearing. And in 2018, there were close to 45 board hearings for every day of the year. And that's,
But is that a resource issue, or is that a statutory interpretation issue?
well, so it's a resource issue insofar as it indicates that there's an opportunity to be heard prior to your board decision, but not every time evidence is developed, because it's an indicative that, where there's a finite amount of resources, you can only give so many board hearings, and at least it's a real world consideration as to whether or not Congress intended for an appellant or a claimant to receive a board hearing every single time evidence is developed.
I'd like to understand a little bit more about what you consider to be a decision and what you don't. For example, if somebody files a claim for a rating increase for some disability and it's denied at the RO, appealed to the board remands it for an exam. Then the RO grants a rating increase, but there is still a higher rating available. The veteran wants the maximum relief. It returns to the board. Would the veteran be entitled to a second hearing at that instance because they got some relief at the RO? Is it a new claim? Is it the same claim? Is it a new decision? Is it a different decision?
So the appeal would be based upon the fact of whether or not a new NOD and Form 9 would be required. So in that
Well, I don't think there is, because if there's a maximum rating, you didn't get all the benefits you're entitled to, it automatically returns to the board.
Correct, Your Honor.
But relief was provided, which I think was part of your criterion, but it was provided by the RO. So I'm confused.
Yeah, so the context would be whether the board had ruled on the underlying request for relief. So in that case, had the board addressed the issue of whether an increased rating was, the claimant in that circumstance was entitled to an increased rating, it had not, so there was not a final board decision under 7104.
So no hearing.
Wouldn't trigger the requirement for a new hearing. That's not to say that a claimant can't request one, because as pointed out under 20.1304, after a Form 9 is filed, a further hearing can be requested, but that also presupposes that one hadn't happened. So even though the board may be able to give one, it's not to say that they would be entitled to one, and it's within the discretion of the board to provide one.
What if, okay, again, continuing my scenarios here, what if a veteran has two claims that are before the RO, one's for service connection, one's for rating increase. The RO denies it, goes to the board, they have a hearing, the board remands both of them, the RO grants service connection, doesn't grant the rating increase. They both go back to the board because the rating that's assigned for the service connection is something that they disagree with, the veteran disagrees with. Would the veteran be entitled to a hearing on any or all of that?
I'm sorry.
I know it's complicated.
There was a claim for service connection that was remanded and thereafter granted.
Yes.
In that case, increased rating would be a downstream issue in which an NOD would be required and a Form 9 would be required. So they would be entitled to a board hearing for the increased rating claim after they appealed that to the board.
And veterans are expected to understand all this. So who gets to decide whether the veteran gets an additional rating? In Ms. Quinn's claim, I believe the RO told her she wasn't entitled to a hearing, but the board didn't discuss it. And in Cook, the RO deferred basically a decision on the hearing, I believe, and the board then said one was not available to her.
Sure, Your Honor.
What should happen here?
So it depends on the circumstances. In circumstances unlike this case where or I guess the earlier part of this case where an original board decision or board hearing was requested when the Form 9 was filed, that determination is made by the RO. But where it's made after the Form 9 is filed, in other words, because there was delay, that the request for a second board hearing under 1304 must be made to the board, and the board makes a decision on that. Here, appellant's request was never made to the board. It was only made to the RO. Even putting that aside, though, the RO denied it, and then appellant, claimant at the time, through the same counsel that now represents her, did not raise that issue to the board for the following 7 months prior to the board decision which was issued.
So what's the authority for having to raise it again? I mean, so you're saying, as I just understood your answer originally to Judge Sholin, and I think it was a good answer in the sense that it depends on when the request is made, who's going to decide it, right? But if it's not made, so here it's made to the RO says no. Is it the government's position that then, in order to preserve the issue for our appellate review, the claimant needs to do something else?
Yes, Your Honor. The claimant would need to do what's required under the regulation 1304 and request it specifically from the board.
So it's weird. This is, you're younger than I am, so this was beyond you. But at one point in time, you're familiar in a trial, for example, that if evidence is coming in that you don't think is going to come in, you object, right? We all know that, right? Objection. And the judge says, overruled. Well, in the old days, and in Massachusetts where I practiced, the old days continued for a long time. It wasn't enough for you to say, objection, overruled. You had to say, if you were the lawyer really meaning it, you'd have to say exception, meaning I really, really mean it, and that would preserve it for appeal, right? That's all been stripped away now. All you got to do is objection, overruled, and I've preserved it. Doesn't it seem a bit odd that in the full throes of the adversary system, that's all that has to happen? But in this system, that is pro-claimant, non-adversarial, the veteran says, I want a hearing, they're told no, and then that doesn't preserve it for appeal unless the veteran says the equivalent of exception. Do you get my sense that it's hard to...
I do, Your Honor, and I think that whether to invoke exhaustion is within the ability of the court, but it also is within the court to rely upon case law such as Robinson to say that it's within the record, right? But then the question then becomes, if that's the case, did the board have an obligation to address it, and if they did, was there prejudice? Here, the Secretary would assert that the board did not have an obligation to address it because it's as a matter of law. They're not in Miss Quinn. We've been talking a lot about Cook. Ms. Quinn got what she was entitled to under 7107B, what 7107B requires, so they didn't have to talk about it because as a matter of law, she wasn't entitled to it. And even if they were required to talk about it, there still hasn't been an adequate showing of prejudice to show that the balance of evidence below would have changed based on the opportunity to testify, or Ms. Quinn still hasn't provided any indication as to what she would have testified to or contested any of the specific board findings made in the decision now on appeal. Rather, the only issue that Ms. Quinn has ever raised to this court was that she wanted the opportunity to testify.
Isn't that similar, though, to our, by our, I mean the court's analysis of prejudicial error in Cook 1? I mean, that's basically what Judge Bartley, as I read Judge Bartley's majority opinion in that case, and I'll defer to Judge Peach, who was on the panel, but that seemed to be what the court was saying, is the veteran wanted to testify, Mr. Cook wanted to testify, and we can't tell how that would have played out given the nature of what testimony is, basically.
I don't recall in Cook whether or not there was an assertion as to what Mr. Cook would have testified to, but the Secretary would still point out that in that case, Mr. Cook had other allegations of error, and the court didn't get to those allegations. But there still was an allegation that the board improperly decided something below, and that would have given Mr. Cook the opportunity, presumably, to talk about those issues at a board hearing, right? Like, here's how I want to present my evidence. Here's the way that I'm going to buttress my argument, and Here, there's no assertion that the board did anything improper based on the evidence as it existed. I think that changes the balancing of whether or not there was prejudice in this case. The Secretary still would assert that there should be a requirement to show prejudice as to how any testimony would change what's going on below, because that's essentially what's required for prejudice. And as Your Honor pointed out, even in constitutional challenges, there's still a requirement to show prejudice. Here, where there's been no assertion as to what would have been testified to, how it would have changed the balance, appellant, the Secretary would assert, hasn't met her burden to show that prejudice.
I'd like to go back to your discussion about needing a notice of appeal.
I'm sorry?
Your discussion about needing to file a new NOD, Yes,
Your Honor.
And a statement of the case, and some of the distinctions you tried to make. I will admit I did not go back and listen to the Federal Circuit's argument in Cook, but they do reference on the last page of their decision that the Secretary made an argument about how you define an appeal as consisting of something where there was a notice of disagreement filed and a statement of the case. And they think that some of these authorities may help to illuminate the meaning of appeal, but they don't resolve the question because 7107B conditions the board deciding an appeal and affording an appellant an opportunity for a hearing. When an appeal is again reviewed and decided by the board on remand, a claimant is entitled to an additional opportunity for a hearing. I find that word, an appeal is again reviewed and decided, to potentially be significant with regard to your determination or your definition of what a decision again. If you can review something, that means they're looking at it more than once. So therefore, there could be a subsequent decision.
Correct, Your Honor. In a circumstance where a higher tribunal or higher authority vacates that prior board decision and requires a new board decision. So it's not necessarily the appeal that is important in that scenario. In that scenario, where a new board decision is required because a prior one had been vacated, and because 7107B requires that prior to any decision, the claimant be entitled to an opportunity for a hearing, an opportunity for a hearing was required.
So you place more significance on the fact that the decision is voided by our court than the fact that it's coming back up from the RO.
Yes, Your Honor.
Let me follow up on that. I asked the appellant the question about what does the term under these circumstances mean, because the court in the Fed Circuit agreed the bottom line with us, but the reasoning was different. But then said, under these circumstances. So I'd like to get a handle on where we can apply the Fed Circuit decision. What are these circumstances?
Yes, Your Honor. These circumstances would be the specific circumstance of that case where a higher tribunal had vacated a prior board decision. And even though that claimant had received a board hearing, because a new board decision was necessary, the opportunity for a new board hearing was necessary again, but prior to it being decided on the merits.
A higher tribunal, are you referring to a court, or could it be a board?
It would have to be the court. So the board provides one final review. It's one review by the Secretary, and that subsumes everything below it. So the lower decision would not matter. It would have to come from the court in that circumstance.
So your interpretation of the Fed Circuit Court decision is that it applies only, a hearing would be granted only where this court vacated the decision.
Ton, please add 2 minutes. Sorry.
But nothing, it would have to come from this court.
Yes,
In
sir.
order for Cook Fed Circuit to apply.
Yes, Your Honor. That is the Secretary's interpretation.
No other distinguishing circumstances other than the court has to have been up here and sent back down?
Yes, that's correct, Your Honor. So where there was a prior final board decision and it was vacated, and it was sent back down for a new board decision. 7107B would require a new board hearing. But where there was only one board decision, in this case on the claims on appeal, an appellant was given the opportunity to and did testify prior to that decision, 7107B was satisfied under that analysis.
I don't think that the fact that in Cook, there never was a board hearing on the merits. It was on the new and material evidence issue.
I understand, Your Honor. So in that scenario, that wasn't what the Federal Circuit relied on. But their reasoning, I think, even though that's not the circumstances in this case, in Cook there were two board decisions, right? The first one was deciding that there was new and material evidence, after which the merits of the claims were developed, and a new board decision was required on the merits.
With no hearing.
With no hearing. Now, the Secretary is not taking a definitive stance on that, but I think it would be a reasonable reading of the Federal Circuit's decision that in that scenario, a board hearing may be required. Here, though, Your Honor, that is not the circumstance. Here, there was only a remand. There was never a final board decision on any portion of the claim on appeal until the decision now on appeal.
Would you like more time? Yes. Don, please add 2 more minutes.
Just before you sit down, I was wondering if I could ask you the same type of questions I asked Mr. Carpenter about, does the Secretary have any position about whether there is any relevance to this appeal of 38 CFR 20.1507?
No, Your Honor, that's not relevant to this appeal because it's under a chapter that deals with expedited claims, and here this is not an expedited claim.
Thank you. That was what I was hoping you'd say.
You're welcome, Your Honor. Unless Your Honors have any more questions, the Secretary respectfully requests that the Court affirm the board decision on appeal because the appellant was entitled to an opportunity to a board hearing prior to the decision, and that is what she received, Your Honor.
Thank you very much. The case will be submitted for a decision. The court is now adjourned. Oh, I'm so sorry. I'm done. Just kidding.
Judge Solid is one of our senior judges.
It's true, so close. I just had a birthday. Please, Mr. Carpenter, take a moment to get your breath and then you may proceed. You'll have 10 minutes. Oh my, I think my father's even watching.
And may it please the Court. I'd like to follow up on the last question that you raised because I think one of the reasons the regulation didn't come to mind was that I'm not sure that regulation existed at the time in which Cook was decided. And just to amplify on what the government said in terms of it not applying because it's for expedited treatment, it was specifically related to a program developed by the VA after the enactment of the new appeals process, or in anticipation of that, so that there would be a pilot program, and within that pilot program, this limitation was imposed. So I'm not sure that it was even available, although it's entirely possible. I can't tell from the website that I have available as to the exact date that was done or whether there was previous expedited treatment language in there before. But in any event, to move to the question, Judge Peach, that you raised about the circumstances, clearly at issue in Cook was only the question of what happens on remand from this court. But I think what is missed by the government's analysis is that we are examining the text of 7107B. 7107B makes no reference to remand. Remand isn't in the statutory language. So how could it possibly be relevant whether it was a remand from this court or a remand from the board that is returning? All that is covered is before a decision on any appeal. So as part of the decision-making process, Congress mandated to the board that before you make any decision on any appeal, you must afford a hearing. Now, I understand the resource issue, but the resource issue has nothing to do with the statutory interpretation question, which was resolved in its entirety by the Federal Circuit in Cook. There is no wiggle room for the VA to come back at this point and say, but this is distinguishable. It is not distinguishable. And it is not distinguishable because we're only talking about the confines of that statute. And the confines of the statute are only about affording a hearing before deciding any appeal. And that didn't happen. And whether it was requested at the RO and then ignored by the board is not the issue. Because even if it had been addressed by the board, they would have been obligated to follow it. The fact that they chose to ignore it does not vitiate their obligation under the statute to afford a hearing when there was a clear expression by Mrs. Quinn, a person that is supposed to be treated in a non-adversarial way, that she desired to testify. And that desire to testify is what is enshrined, if you will, in the provisions of 7107B as interpreted by the Federal Circuit in Cook.
Are you familiar with the new 7107 provision?
I am, Your Honor.
Do you see any difference in the language in that would be helpful in interpreting what our 7107 means?
Well, first what I note is the absence of this language. And as I understand the new process, and I'm still in candor struggling to get my arms completely around it, but as I believe I understand the process, this situation as presented in this case is likely no longer to be able to happen because the VA treats under the statute, or mayhaps Congress treats under the statute, a disposition by the board to be something that is either continued with a new supplemental claim, or if returned on remand for a duty to assist violation, that new decision, that decision made by the RO becomes a new decision which is subject to a new NOD requirement if you choose to return to the board. And obviously, in that context, this problem should never arise again. So we're really only dealing with the legacy appeals, which I know are probably 500,000 veterans, but in any event, there are still many, many veterans that are potentially subject to returning to the board in the exact same circumstances as Mrs. Quinn was in. It is crucial for them to be able to have the right to a hearing. If they choose not to exercise that, if they choose to be expeditious, develop their evidence and present their evidence in different ways, then it's a non-issue.
If you could clarify something for me, because we have not seen any cases relating to the new system yet. So let's say we agree with you and find error in Mrs. Quinn's case, and we remand it to the board, and they do a hearing, and they decide they need to remand for some reason. Is she now participating in the new system?
No.
Okay.
She's still in the legacy system. Now, she would have an opportunity to what they call opt in, but only after the remand instructions are completed and there is an SSOC issued. If there is a new decision issued that grants in part, as was one of your examples, I believe, I understand the VA's position to be now that that decision, because it was partially favorable, would be a new decision that would be subject to the new appeal process. But unless there are further questions from the panel, I don't believe I have anything else.
And now, thank you very much. The case will be submitted for a decision, and the court will now be adjourned, and we will come down and greet kids. Thank you.
All right.
This is my left arm. Get it right.